Thank you.
Thank you, Madam Chair. Each of you have kind of just briefly touched on the litigation aspects as a result, and what I'm talking about is third-party litigation. If some of the proposals out there for the Clean Water Act were implemented, could you tell me, from your perspectives, each of you, and we'll start with Mr. Cruz, can you tell me how you see third-party activist groups, at least the litigation from them, increasing if this were implemented, and what that's going to mean to agriculture and small business in the future?
I think that's one of the greatest concerns we all have, and I'd refer back, Congressman Graves, to a comment you made during your opening comments about farmers and ranchers striving to be good stewards of the land. And I think that, without a doubt, is something that we all strive to do, is take care of the land that we are temporarily empowered to take care of. I think the worst case scenario, and I think this would indeed happen, and some of the panel members have already mentioned it, you know, if the word navigable is taken out of the Clean Water Act, then we're talking about every pond, every lake, every stream, every puddle, ephemeral areas, which are areas where after a rain water may stand temporarily and then go away, and so you might have an area where water might stand after a rain for a few days a year and be dry the majority of days of the year, but that would be under the jurisdiction of the federal government. And you know, I can see a scenario which we see all the time where an attorney shows up and representing a client, and thousands and thousands and thousands of dollars later, and much time and agony, you could well almost be without a farm or a ranch after trying to defend yourself because of a third-party lawsuit. And you know, I think the fear we all have is, whatever the intent of Congress might be, the courts will probably end up, if the word navigable is taken out of this, the courts will end up deciding what's going to happen and what our fate's going to be, and that's not something we really want to think about.
Dudley?
Thank you. I echo the same concerns that Mr. Crucy has on the word all instead of navigable. In my testimony, I mentioned basically groundwater. We install water lines, sanitary sewer lines, and don't expect many of you members of Congress to know this unless you're in the business, or most people in the public know this, but there is typically groundwater everywhere. And in some locations, you know, like in my home city, you can go down 8 feet and you can hit groundwater. And it's not a rushing water, but it's water that seeps in. And in order to keep our excavation safe and keep the projects moving forward, we have to pump the water out of that excavation and then put in a suitable backfill and then place the pipes in there. Under this rule, that groundwater, whether I know it's there or not, I have to get a 404 permit. So I could be going along at the start of my project and the ground is perfectly dry, and I come up to an area where there is groundwater coming in, because there's no amount, it just says all waters, and if I have to start pumping it, then I have to shut down, get a 404 permit, and I don't know how far that groundwater is going to go for. It could go for the entire length of the project, or it could only maybe go for 100 feet or so. So it's this opens up a huge issue, especially in our market for this issue. And I think it's something that's completely unattended by the word of inserting all instead of navigable. And any third party who could be driving by and they see a pump running in an excavation could lead to asking, where's your 404 permit? And I see that as a very dangerous situation for all of us.
Mr. Chilton?
I'm a victim of third-party lawsuits. Our ranching operations have been affected by 4 separate lawsuits filed by the Center for Biological Diversity. The Center for Biological Diversity standard operating procedure sues the federal government. In this case, in all 3 cases, the Forest Service, and 1 case, the BLM, Bureau of Land Management. They accuse the Forest Service or BLM as having not done something. In 3 of the cases, it was properly consult with the U.S. Fish and Wildlife on endangered species. Problem is the Center for Biological Diversity submits information in our case that was not even true. They were lies. They were misrepresentations. I got so angry because of being a victim of a third-party lawsuit that I sued the Center for Biological Diversity for libel, misrepresentation, and plain lying. And the jury came back and said 10-0, the Center for Biological Diversity was guilty, 9-1 that they awarded me $100,000 damages, and 9-1 that they gave me $500,000 punitive damages, punishment for the center lying about us. And it's just really awful as a citizen of the United States to have your ranch and farm and you're being a good steward, and I've gotten all kinds of environmental awards for being a good steward. It's really, really awful to have a radical environmental group sue the government, and they're really after you. They're suing the government to get rid of me. And as a citizen, it's just upsetting. You roll over at night, you get angry, and it's just awful. Why is a citizen of the United States put through such horrible circumstances? I really object. It's just awful with these third-party lawsuits.
Mr. Gray?
Congressman Graves, I certainly agree. I can't add too much to what's been stated, although I would add a point. We had a dairy producer in my home county, Cuyahoga County, was sued on a nutrient management issue by a third party. This lawsuit went on for almost 10 years, and the dairy producer won it in the end and has got some of the money back that they had put in the legal fees. This will, no question, this issue will spur more lawsuits. But you can imagine having that hanging over you for that length of time. I mean, really, justice delayed is justice denied. And I can't believe that this won't increase litigation by third-party litigation much greater.
Mr. Schellenberg?
Mr. Graves, one of the things that Armadillo does is we do a lot of culvert replacement and remediation work for both the highways as well as the railroads. And quite often, even we're working under the existing Clean Water Act and have all the permits, and people come out and they're opposed to you fixing the existing culverts and infrastructure of these important railroads and highways. If we don't fix those things, what happens is you get a washout on the railroad or highway. You've got far greater damage downstream. Now so people are opposed when you're doing things right. Now you take that further and you move it to expand that out. You got puddles, you got this and that. Especially in Oregon, I can see significant different groups coming forward, just trying to stop urban growth, just trying to stop anything that not my backyard type of things. And they're going to say, now we have a vehicle that we can use. We're going to say this is a wetland. We can use that to prevent development, prevent any kind of necessary infrastructure that we need in our communities.
Thank you.
May I add one more comment?
Real quick. Yeah.
The people who sue under third-party lawsuits often then collect money from the U.S. government under the Equal Access for Justice law. So it's a cottage industry. It's an industry to sue the government and collect money. This is wrong. This is not a democracy. The federal government ends up paying for their suing third parties.